This is part 2 of a presentation on the federal mining tax and federalism. The federal mining tax came from the Henry Tax Review undertaken by the head of the Treasury into the taxation system of Australia. The federal government took out of that only a few matters, one of which was the mining tax. Although the then Prime Minister, Mr. Rudd, was supposed to be reluctant, Nicholson of the Australians saw it this way: Wayne, not now, not now. But the Treasurer went ahead. We got a new mining tax, and that was greeted with very strong opposition. Nicholson saw it this way afterwards. There are the miners in the roll. Down the front, at the bottom of the guillotine, is Madame Lafarge doing her knitting, played by Julia Gillard. There's the Treasurer, Mr. Swan, about to read the sentence as if he were the President of the Tribunal, and there's the Prime Minister, Mr. Rudd, seeking a compromise. Any thoughts on how we can improve the design of this thing? Nicholson was prescient because in recent times we've learned that before he was overthrown, Mr. Rudd was in the process of working out a compromise with the miners before he was overthrown by Miss Gillard and Mr. Swan. Such is politics. The resource super profits tax, that's the first version, and its successor, raise certain fundamental constitutional and legal issues. Is it a Commonwealth tax on state property? And if it is, there are problems for the Commonwealth. Was it, in relation to the first tax, an acquisition or nationalisation of 40%? You may recall that the tax involved not only taxing 40% of super profits, but bearing 40% of losses, though few thought that this would be carried through if a major foreign investor incurred a very substantial loss. The third point was who owns the minerals, and was it the Crown who owns the minerals? And of course then the Crown in the right of the Commonwealth, or the Crown in the right of the states. And the final legal question was it a breach of Australia's international obligations concerning foreign investment? Choosing the term super profits was indeed curious. It seems to have a Marxist origin, and Lenin used it in his principal book on imperialism. There seemed to be a Marxist-Leninist air about the whole thing, particularly as super profits were cast at a surprisingly low level, that is the long-term bond rate. Anything you owned after banking your money safely with the Commonwealth would be treated as a super profits tax. So foreign investors in particular were wondering about a tax which seemed to have these Marxist-Leninist overtones. The tax, of course, has to be seen in the context of federalism. In a federation we have a separation of powers, where the judicial power, the courts, are separate from the legislature and the executive, something which started in Britain and spread beyond. But we also have, from the time of the American Revolution, or rather after the American Revolution, when the former colonies united, we have a division of power, which means that the individual states have certain powers and the central government, the Commonwealth, has others. But the principle was this, that in such a federation the states should have an independent and uncontrollable authority to raise their own revenues for the supply of their own wants. And this can be best illustrated in the 2007 Toomey Withers report to the Council of Australian Federation. The authors found that Australia is the most fiscally centralised of federations in the developed world, the OECD world. That means our federal government takes a higher proportion of the total tax take than the American government, the Canadian government, the German government, or the Swiss government. In fact, our states raise only about half of what they spend. Of total public spending, the states bear about 40%, but they raise only half of that from taxes. And that goes against the principle that they should be responsible to the people who elect them for the money they spend. And some of the breakdown in some states in relation to accountability can well be traced back to this. They also found, for those who would abolish the states, that being a federation makes us 10% richer than we would be otherwise. In other words, if we were to abolish the states over time, we would be poorer, they say, about 10% poorer. They say this could be raised significantly if the states became more responsible for raising their own money. They predicted up to $4,000 odd, probably in today's money up to $5,000 on average incomes. That's a lot of money, particularly for a family. On the screen now, we're coming to the question of who owns the minerals. And I've put up a Crown grant from Fiji, only because it's very similar to ours, but ours by the colonial governments are in beautiful copyright and very difficult to see. If you go to the central paragraph beginning with the words, "We do hereby reserve to us," you'll see there a reservation of all metals, coals and minerals, and crude oil, to the Crown. And that establishes who owns the minerals. They're normally owned by the Crown because when the Crown granted the land to private landholders, the Crown kept the minerals. But it's the Crown in the right of the state, not the Crown in the right of the Commonwealth. So when the federal government was saying in 2010, oh, these minerals belong to the people of Australia, that wasn't accurate. They belong to the Crown in the right of the states. But there are exceptions, and I'm coming to one now, and that was in the state of New South Wales. In New South Wales, the New South Wales coal reserves in some parts were not reserved to the Crown. Unusually, they went with the land so that the royalties became privately owned. The Rand government found that this was unacceptable and in 1981 nationalised all coal. But they didn't pay just terms as the Commonwealth would have had to have had it nationalised property. The compensation was very low. That was reversed by a subsequent coalition government, but reversed again to an extent by the Labour government of Mr. Carr. There are two lessons to be drawn from this. The first obvious one, that there ought to be a provision in state constitutions providing for compensation, but most importantly for our purposes, it's very clear the minerals here belong to the Crown or they belong to the landholder, the individual landholder. They don't belong to the Commonwealth government. And unnationalised, they're in private hands if they weren't reserved. Otherwise they're reserved, but they're reserved to the Crown in the right of the state.